Oh, you're the reporting officer for this, so we can start now, right? Okay. Welcome back, everybody. We now move to our first late morning submission, Mr. Peter Malcolm. Good morning, Mr. Malcolm. You've got a PowerPoint presentation to present to us?
Yes, thank you.
Okay, we're in your hands. Thank you.
But I've got a property in which I bought in the 1980s. Recently it's been zoned or proposed zone as rural lifestyle, and I strongly support that particular designation. There's a bit of opposition to it from various quarters, I understand that. But coming back to my place, the portion of my farm is currently zoned as basically coastal, and there's no indigenous vegetation on my farm. Now, one of the things about this particular farm is the soil type is actually called so Hokulunui silt loam with the yellow subsoil. This soil type has physical characteristics which severely limit its productivity. The soil type has poor fertility, poor drainage, and is drought prone, and it's not suitable for cropping and cultivation due to soil structure. The other thing too is that planted trees are slow growing and prone to wind throw. This is not a productive, elite, versatile soil. It's not like the soil, say, up and down between Rangiroa and Kerikeri, along in that road there. You've got, say, Kerikeri deep phase soils, highly productive, which are on the irrigation scheme. Same sort of soils which you've got between, say, Kerikeri Township and State Highway 10, up by the roundabout. All those soils were on the Kerikeri irrigation scheme, and basically they are elite soils as well. They've all been compromised by basically urban development over the last period of time. It's the same to some extent with some of the soils up Kapiro Road. You've got the Kaiel soils, a lot of them have also been compromised by urban development. As far as the landscape is concerned, this farm is not on the Auckland Regional Council schedule of outstanding landscapes, nor on the schedule of outstanding natural features, nor on the schedule of high natural character. The proposed rural lifestyle allows for low-density residential activities and small-scale farming activities that are compatible with the rural character and amenity of the zone. And it allows for appropriate setbacks from high water tables, wetlands and lake river margins, and it does allow for subdivision down to 2 hectares. Now, currently it's designated as South Kerikeri Inlet Zone in the current district plan, and that restricts development due to supposed visual sensitivity, coastal location, and the presence of significant water bodies and wetlands. There's a lot of people who basically oppose any sort of development. We've got various people such as hunters and shooters who want to go through and be able to shoot through the area, and fishers as well. And you've also got various other people who want to push development out in other areas.
How is the development restricted? Is that, are you saying is the 2 hectare subdivision? Is that
is basically what the proposed
I see.
Rules will allow.
Yeah.
And so currently it's under the current situation, it's very difficult to do anything.
Okay, thanks.
Now, as far as I'll address some of the issues, as far as visual sensitivity is concerned, this works, but it doesn't work on the screen.
Yeah.
So I'll have to just go through it. Yeah. The area above the trees here is supposedly visually insensitive, so people can actually go through it and build. The area underneath the trees on my place is designated as visually sensitive, so it limits what you can actually do there. So it seems to be a bit of an anomaly in that situation. If you look at the same situation, you can see in above there by the power pole, area above the power pole up there is basically designated as visually insensitive. The area below the power pole is currently designated as visually sensitive. So once again, a bit of an anomaly. And you can see at the top up there, you've got several big buildings which are on the actual ridge line and quite visible from some distance away. If you look further afield, you can see that you can see that there's basically a house down through here. There's a 2.6 hectare title through there. That is designated as visually insensitive. The land the land around the top up there where those buildings were before is designated as insensitive, but the land in between the two is basically designated as visually sensitive. As far as wetlands are concerned, there's a popular misconception that the Waitangi wetlands are in the South Kerikeri Inlet Zone. They are not. The only water bodies, or significant water bodies on the farm in that area, there are two significant water bodies. The first one is on my place, and this is you can see there, this is a dam which was built in the 1950s and so on. And basically that dam is fed by runoff water from my farm. It's not a river, it's not a stream or anything like that. It's just basically runoff water collected from the farm and it's used for farm water reticulation purposes. Water from there is actually pumped around the actual farm itself. So that there's some groups who want to go through and hunt and shoot and everything else. There certainly will be no hunting or shooting on my place. The other significant water body, once again, is also a farm which was built, a dam which was built in the 1950s to provide water to adjacent properties. The Northern Regional Council description describes it as a shallow constructed artificial pond lacking riparian cover. And the title deed, basically for the hunters and shooters, the title deed is a separate title for the dam, says no shooting, fishing, boating, and prescribes the daily amount of water adjoining properties can use. Regarding coastal, there's an area in the back of my farm which is basically designated coastal. And you can see there's the flats here. There's probably about 15 hectares there, but you cannot see the sea, and the sea and that portion of the farm cannot be seen from the sea. This is another image of the same particular location. Once again, it's not visible on the sea nor any part of the road. Now I realise that basically this probably the designation was done because of a desktop study, and I understand they have their uses, but sometimes you actually have to get out there and actually have a look at the actual contour, the actual situation as well. It's a bit like, say, 150 odd years ago, you had people in London going through and surveying up blocks in New Zealand for subdivision, and without taking into account the contour, whether or not the actual proposed subdivision was actually in a swamp or anything like that. So in summary, I'd like to strongly support the rural designation of this area in the proposed redistrict plan. The proposed rural lifestyle designation will allow for low density residential activity and small scale activities that are compatible with the rural character and amenity of the area. The area is close to Kerikeri. The area has poor unversatile soils. It's not like some of the other areas around the Kerikeri area, which on the irrigation scheme. It's, so Kapiro Road, for instance, where there's talk about trying to put rural lifestyle areas in that area. The designation of rural lifestyle to other locations close to Kiri will compromise irrigated productive versatile soils in close proximity to Kiri. And lastly, I'd like to thank you all for your time and attention.
Thank you, Mr. Malcolm. So you're basically supporting the zoning that
I am indeed.
and coming here to reinforce the
Exactly.
council's assessment
Exactly.
and recommended zoning. So thank you for that. It's good to hear support. It's usually people saying they don't like the zoning on their land. You said that your land doesn't have versatile soils. Have you engaged somebody who's expert in those sorts of things to confirm that? Do you know what class of soil?
It is, as I said, still low. I have some knowledge of soils. I have worked with soils in different parts of the world, and I certainly do have some sort of professional knowledge and understanding.
New Zealand uses the land use soil classification. Land use 1, 2, 3, up to 9. What do you think your soils are?
About 5.
About 5, and that's 5. I think associated. It looks like your site's reasonably flat. So is it just because of the very, very shallow soil profile?
It's probably 4 or 5.
Yeah. Okay. No. Thank you for that. That makes sense to me. Anybody else?
Yeah. So you support the rural lifestyle zoning, but you've got a coastal overlay that applies as well. Is that correct?
That's correct. Yes.
Yeah. But you're not happy with the mapping of that?
I'm not happy with the mapping of that. Basically, I think it was a desktop study, and I wasn't around in the country at the time when that work was done. I was working on overseas aid projects, and I was in areas which were not accessible.
That 2 hectares is the minimum for subdivision. Is that making good use of the land?
I would think it would be, because as I said, agriculturally, it's not the most productive. And I would be very disappointed if you had situations, say, which has been proposed by various groups that, say, along the Ōmāpere Road, you've got the different kaiau type soils, which are versatile and which are on the irrigation scheme. I think it'd be very disappointing to actually have 2 hectare blocks allowed in that particular location.
So why in your location wouldn't it be 1 hectare?
Well, that's a possibility as well. But as I said, I think 2 hectares allows for rural lifestyle, which is what they're actually looking at as far as the designation is concerned. But certainly 1 hectare would be something which could be considered.
Thanks.
Just before I go on to others, so you've got an issue with the coastal environment, and I'm just looking to see if that's mentioned in your submission in terms of the relief. You refer to it in your submission. And in your further, okay, no, yep. Satisfied you've got scope, that's all I was check out.
Just a supplementary question relating to the coastal overlay. In your further submission, it talks about removal of the coastal overlay for rural lifestyle, not only in Russell, but also around Kirikiri.
Yeah.
But it's quite short, your submission, and I don't really have context about the Russell nor around Kirikiri. I think you've highlighted the sites in the Kirikiri inlet in that area.
But basically, my understanding is that there's rural lifestyle areas over in Russell as well, in the Russell area, and this area is proposed rural lifestyle as well. So if you, part of the property has got a coastal overlay. Once again, I think in that situation, in the road, I think the removal of that coastal overlay, as far as potential development opportunities and so on is concerned, I think would be advantageous. I think the other thing too is I note that there's also restrictions on building size as well, in that particular proposed zoning, whereas in other areas, urban areas, there's no such restriction.
Do that was to get more context.
Thank you.
Yeah, thank you, Mr. Malcolm. I just wouldn't mind a clarification on your address. At which end of the Inlet Road are you? At the western end, are you?
I'm at the western. So if you go down Inlet Road,
Yeah.
you go past Ringer Road, you've got the one lane bridge at the end, at the bottom.
Yeah.
And then on the right-hand side, you've got Waitangi Forest.
Yeah.
And on the left-hand side, you've got my place.
Yeah. 405.
Well, it's round about 405, but I said I'm a bit further up. It's basically 481, but it goes right round and down around the surrounding properties, 405 and so on as well.
Yeah.
So if you look for 481, you'll see that there's the larger river.
Oh yeah, I'm 481. I see you there. So the coastal environment overlay is just that area at the bottom. So part of your property
Yeah,
is this coastal environment, and other parts of your property don't have it.
Yeah,
But it's the part of your property where it is.
yeah, but also the other thing too, that a number of the surrounding properties have also got the same coastal overlay as well.
Yeah.
I think it's in 481, if you see that view.
Yeah, I'm just looking at it on the map. And I think that correlates with the photos you showed. I can sort of see how that works. Yeah. Okay. Thank you.
Well, we have no further questions for you. So thank you very much for your submission and your presentation today.
Thank you
And
very
the
much.
answers to our questions.
Thank you very much for your time and attention. Thank you.
Thank you.
Now, we don't have the next two submitters here. Either we do have Chris Schmidt, Living Water.
Kia ora, Mr. Richmond, would you like to come up and have a seat?
Good morning, panelists. Panelists or commissioners?
Commissioners.
Commissioners. Nice. I presume you've got that on your screen in front of you, or? Yes, yeah, that's right.
Now, thank you.
Okay, thank you for the opportunity to present the submission. So this is the submission from Living Waters Bay of Islands. My name is Chris Richmond. I'm the submission convener and previously the chair of Living Waters Bay of Islands. And Living Waters is the catchment arm of Bay of Islands Maritime Park Incorporated. And it's a volunteer-led charity that works to restore the ecological health and natural character of the Bay of Islands and its catchments. We do that through the development of best practice exemplars of floodplain, coastal and restoration. So, for example, for those of you from Herring, you know the Wairua Stream, by better restoration project there, and also we restoring a floodplain at Tangata, which is a district council conservation covenant, and 100 hectares of district council reserves in Okiato. And we also do that through assisting councils to develop more effective plans to implement matters of national importance in the RMA, and we'll go as far as going to the environmental, as we did with the regional plan, Northern Regional Plan, with our appeals on beaches and fishing controls. So the submission, a bit of an outline of the submission we made.
Do you want to, yeah.
Oops. Right. The first point we made was we're seeking rezoning and conservation covenants for native vegetated unformed legal roads adjoining waterfront margins. That's the Queen's Chain, the necessity to protect its natural character. The second point, we saw correction of the mistranscribed unique identifiers in schedules 7 and 8 of the high and outstanding natural character regional policy statement. And we also supported the submissions for 10 supported forest and birds submissions seeking consistency with the outcomes and natural character. So on the first point, across. One of the problems with the proposed district plan is that some of the coastal zonings are inadequately protective of the natural values present. And the current issue appears to be a protocol that only one zoning can be applied to each property or allotment. So this means that when was the second permanent conservation covenants and unformed legal roads with native vegetation adjoining water bodies do not qualify for natural open space zonings. So each of these units, land units, do not have a surveyed allotment number. They do actually have a Farmers District Council parcel number as a unique identifier. So the relief that we're seeking is to apply natural open space zonings to those parcels which are protected by QE2 or Farmers District Council permanent conservation covenants, and also to unformed legal roads with indigenous vegetation that adjoin rivers, lakes, or the CMA to give effect to the natural character protections and restoration imperatives of the RMA and NZCBS. And the second option here is in going through the zoning maps, I've noted in one particular neck of the woods, Bay of Islands, that there are a lot of anomalies in the zonings that have been applied, presumably on desktop rather than on the ground, as the previous submitter pointed out. And this is just one example of the many zoning issues in the Bay of Islands. This is zoned rural production rather than residential. It happens to be a rental property called the Boathouse. It's number 5 Beachy Street, Ōmāpere, and it's just the start of when you drive onto the boat ramp at the ferry at Ōmāpere. Most of it is actually outside the district council jurisdiction because it's on piles above the water, but it's still all zoned rural production. And I'd really like to suggest that council staff might need to go through thoroughly along some of the zonings that they've applied on water margins, because some of them actually do extend into regional council territory and CMA, and some of them are just quite clearly inappropriate. So it needs to be put control on those zonings. Okay. And we support the inclusion of Schedules 7 and 8, as it does provide information about the terrestrial parts of the natural character units that will measure at the regional policy statement. However, many of the unique identifier numbers have been mistranscribed from the RPS data, making it impossible to dig into the underlying maps, worksheets and tables in the RPS for information about the unit. And so, for example, I'll give you some examples there where the unit numbers are unit number / map number, and they instead misformatted as a date. And as the person who actually assigned those unit numbers to the regional policy statement in the first place, my original mapping, I find it quite frustrating that it seems as if council staff have transcribed the original RPS data into a spreadsheet and then assigned, use date formatting in the third column rather than the default format, which is two numbers separated by a slash. And so the reason is to correct those unit numbers. And some of them are perfectly okay, but all the ones that start with a 0 seem to have been retranscribed as a date. So, for example, September, where it's an 09/36, that's been transcribed as formatted as September 36. Okay, so that should be reasonably straightforward to resolve. Okay, with regard to the further submissions we made on the forest and bird submission 511. Now, the methodology that was used to assess and identify the areas of high outstanding natural character should be based on that used in the RPS, because many of the lower river and lagoon and estuary margins are already described in that in the RPS. The coastal environment zone the coastal environment overlay that the previous submission was talking about was undertaken by Green Water, and it basically extends up rivers to the extent of tidal influence. And so that sometimes in some of these low gradient rivers, that can extend maybe 10 or 15 kilometres upstream of the CMA boundary. So a lot of the rivers that have been mapped in the CMA do extend up into areas where the margins are within the jurisdiction of the District Council. And you'll note on those schedules 7 and 8 that the data there shows the natural character index score for each of those natural character units. And that's because the natural character is actually measured scientifically rather than just being arbitrarily assigned a category. Now, the Northland Regional Council also commissioned research on the natural character of its lakes, rivers and their margins in 2012, and the Lincoln University report identified 10 river sections with high natural character. I can leave with your administrator an extract of that particular report for your edification. So that work is largely been done already. Okay, so that's really, I think, all I have to say at this stage, but certainly open to questions.
And thank you for your submission and your presentation. I'm assuming regarding those notation matters that you referred to, looking at the council officers, you use section 16 to amend those if they're genuine errors?
Yep, since in general, the issues picked up, numbering and the schedules were
Yes.
aware of that, and that has been picked up.
Yeah.
Thanks for pointing that out.
So, sorry to speak in jargon, section 16 of the Resource Management Act allows for the council to make minor corrections and amendments. And so I think you've got the reporting planner saying that they're picking up those things. So thank you for bringing that to our attention. And it seems to me that the other matters that you've set out in your submission very clear. But there might be some other questions from the other commissioners, so I'll do the rounds then before you leave.
Yeah, just those rezoning anomalies, I mean, it's hard to pick those up without them being pointed out to you, isn't it? Are there any particular rezoning anomalies that you want to highlight apart from the one you did in Beachy Street, Ōmāpere?
I just thought that was a particularly strong example, but there are others, particularly around the Ōmāpere Marina as well.
Is that the Coenzo property, Ōmāpere?
No, I'm sure that's controversial.
Yeah, probably for sure. It's got a history, isn't it? Yeah. Oh, that's interesting as well, because we've looked at Ōmāpere yesterday through submissions. Yeah. Thanks. No, nothing else.
Any questions?
I guess just this Lincoln, the Lincoln University study.
Yes.
Why have you given that to us, and what should we do with it?
Oh, I thought that the natural character provisions in the proposed district plan are fairly generic, and they don't really distinguish between, the provisions don't really distinguish between water margin units which are high natural character and those which are less natural character or high natural character. And if work's going to be done on your natural character plan, then I suggest that it's worthwhile, because no reference is made to that in what I can see in the plan. I just thought that it may be useful to actually consider that in looking at the natural character provisions in the plan.
Okay.
But you'll see that I think there are 10 sections of rivers that have been identified as being of high natural character. And they require a high level of protection than the generic provisions in the existing proposed plan.
So you're almost saying that they should be mapped or identified in the plan. The information that's come out of this study should go into the plan as a mapping layer, a bit like a outstanding natural landscape has been mapped, or areas of outstanding natural character being mapped in the coastal environment.
Right, yeah.
You'd want to have that mapping
I think there
through.
needs to be a distinction between areas that have very little natural character left in their margins and those that are of high natural character.
Which is what this is showing.
Yeah.
High, moderate, low.
So I'm not too sure that work was undertaken by a team led by Liverpool University not long after we completed the natural character mapping coastal environment in 2005.
I see Mr. Barrow's name in that list. He was involved in the work, the regional council work, wasn't he? Mike Barrow.
Yes, Mike was one of our partners in doing the natural character mapping. Yeah.
Vicky Frood's not, her name's not on that list. She was involved as well, wasn't she? We heard from her the other day.
That's right. Yes.
Yeah.
She wasn't involved in the river study.
But she was involved in the coastal natural character
Yeah.
work.
Yeah.
And we heard from her and she gave us her methodology statement.
That's right. Yes.
Research. Okay.
She and I.
Well, maybe we'll hear from the staff on this matter in their reply. Yeah. Thank you.
Thank you.
Thank you very much for your submission.
Thank you, Commissioners.
So our next submitter, I think, is J.L. Hayes and Sons. Michael Hayes, is that who you said?
Yes, very good. Thank you.
Would you like to come up and sit up here at the table?
Apologies for being late.
No, that's all right. No, you're on time actually. So
But it's all part of the story. But I had to sort out one of our neighbours, Smith, over another regulation. And his father happened to be Nuku Stewart, Nuku Smith or Nick Smith, who happened to be, he was the one that took to the tribunal over the chief that didn't sign the treaty. He was also a very strong component of Tina Rangatiratanga. And this is actually what I grazed his land, rented his land for about 50 years, and his intention was to try and make use of that land. And because we grazed it, we cleaned it, and that sort of thing. And, but his concept of Tina Rangatira is something that wrong, because his concept was that it was a chief, situation like the chief was in charge of all his parts. And unfortunately, the chief has died, and that family is fighting like cats and dogs. And what is happening is that this is something generally happening now, the younger Maori people, they don't want to do anything with the land, to actually farm it or do anything like that. It actually doesn't involve a wee bit of work. And so, how does this got to do with a lot of the land now? This is not apply to the Maori land. A lot of the Maori land, it's sort of in my submission here, that where it comes from is that I was involved with the first getting the proposed plan chucked out, came the plan, and it was rewritten, the draft plan was rewritten. And we spent hours and hours on that plan, actually going to meetings at the Waimahi North. And so the writing of that plan actually involved people that were involved with the actual land and the problems. And I would just mention, and I shouldn't, but there was Laurie Byers and John Crawford were two people that had a massive lot of work to do with that draft plan. They died not so long ago. And so that draft plan, I was the Bay of Islands president, and Ian Walker was the Northland president. A lot of people know Ian Walker, for better and for worse. And anyway, I was actually involved in raising 20,000 from the community to fight the plan. It was the SNA that was actually what actually was the finish of the plan. And the problem was that, and this is very simply shows what the problem was. See this thing here, in here, there's a whole lot of maps that actually shows the areas involved. What's in bush, what's in pine trees, what's in this, because I've had to have a map. We had a 500 cube permit for milling native timber, and a lot of this is already on maps. You don't have to have another map, basically. It's all there. And I had to say that this is sort of what this King Mitchell and Associates Auckland, this was the crowd that was actually doing the mapping. I had to send my maps down to them so that they could actually, they didn't have the sufficient maps to actually see. So I sent our maps down there. The lady came back and we had a look at one of the places was the map, it was actually tobacco weed and gorse. So obviously it wasn't those things. I took her to another area further up the road and of ours, and on that rock, it was a limestone outcrop. There's a 1,000-year-old tokra, and around that area, naturally, there's certain species that are suitable for where there's limestone surrounding. She turned that down as an SNA because it wasn't fenced. And this is one of the biggest things that's happened. A lot of people have a concept that you've got to keep stock out of trees. And this comes through the whole thing here, that we've got probably 20 hectares of kauri trees. One of the latest things coming in is that you're meant to, the regional council, you can get funding to fence the kauri trees. But those kauri trees, the block of land we got back in the 1900s, and it was bought for the kauri timber and that sort of thing, and then it went into farming. And so that land has had cattle around those kauri trees for that period. If anyone knows anything about the natives in Northland, kauri trees are not affected by stock. Tokra trees are a blooming weed, they grow everywhere. So there's a lot of thought that a lot of people haven't got actually the background to what they're talking about. And see, this is the latest thing with the kauri, that one of the things that concern, and it's in the thing, I see this thing that gives you a headache, that one of the biggest problems with the dieback in kauri is we've got the photo, we're also adjoining the Ōmāpere forest and the Puketi forest and that sort of thing, is the pests, which are obviously the possum and all those sort of things, and we've been doing that. But one of the worst ones is the wild pigs, the pig hunters, and the pig dogs. And fencing off the carry does not stop all those aspects actually going in and being able to take carry back into that area of carry. And as I say, unless you understand this and know about it, the first thing they think about is, we've got to fence it. And this is very much similar to what we've got here with the SNAs, that they've got to fence it. We've got to have a plan to fence it. But that doesn't keep the bugs out and everything. And actually, in fact, in a lot of the country, the big point is that Farmers District Council is not suitable for this sort of situation, the mapping of SNAs. I'll get back to talking about Bryce Smith. The changes, his father died. He tried to do something with that land and we helped him to do it. The new generation don't want to do anything. Because one that does require a bit of work to do anything. And the other thing is that, so that land is going back into wars and then going back to everything else. And this has happened to a lot of the Maryland. And basically, I've got the figures in there, and the figures I use are a third was got, a third was married, a third was general title. Those figures were what we used for the first district plan. It hasn't probably changed, it has changed. There's probably far more land now in Maori ownership that reverted to bush and everything than what there was when we did the plan back in the 90s. And these maps here actually show what from 77, there's a lot of the land, it hasn't gone into taken out of native bush and that, it's all reverting back to native bush, all wars, all the tobacco wheat, and you're coming in here, you can see it all over the place. It's reverting. So the value of actually doing photographing for SNAs is, as I say, futile, because I was one of the ones involved with the first plan. We worked out where we actually had to go to Auckland to see the minister and all that sort of thing. And so we worked out a scheme, a voluntary scheme of actually identifying the SNAs. That went to, when someone came with a certain area, and they needed someone to look at it to see if it had SNAs in it, that was in place, and Dr. Bramley, he was the one that actually had a look at it. Now we did that because that's sort of what the government wouldn't accept it, because the RMA said it had to be, defined. And what happened was that Wayne Brown happened to be the mayor at the time up here, and one story was the district council didn't want to continue funding that scheme of Dr. Bramley actually going out and looking at it and saying yes, no, that's no. But that wasn't correct. Someone objected, and they looked at it and went back and no, you got to be, it's not acceptable because of that having to be in the RMA, that it had to be defined. But as I say, we spent a lot of time trying to do that as an alternative to trying to actually map all the SNAs, and these maps here sort of illustrate, to map the SNAs is just ridiculous in the Far North District area. One thing suits everything does not work. And so basically, my point is that, things have changed. I mentioned about Bryce Smith and the change in the attitude of the new generation. I've also grazed the land from Pat Towell. I think a lot of people would know who Pat Towell was. That land, it's sort of in a family ownership thing. Some of those ones don't like pine trees, so they're cutting all the pine trees out, gum trees, creating a heck of a sedimentation problem. But they want natives. We lease the property and we sort of have to get around this. But another aspect is, and this comes through in the regional council, is that they want to fence the waterways and plant with poplars and willows and that sort of thing. They have forgotten, well, they were never here. Back in the 1920s, we were on priority rivers in Kiowa there. They had they planted willow trees everywhere. What happened? It creates flooding. And so all those willow trees were cut out in about the 1980s to lessen, but then the young people on that property think that they think that you have a river or a stream and you have native bush that actually covers it for the purpose of encouraging the invertebrate and all that sort of thing. But that's not correct. If you're coming through here, you've got total trees right beside the rivers, but they're not overhanging like the willow trees. And so they've got the concept that, another thing is that in this particular river, there never has been trout. But they think that if we put trees that shade the river, that they'll come back in, but that doesn't work because it's purely a temperature thing for that particular river. And so we've got this perception with the young people coming through now that is totally haywire. And there's an instance where there's a big willow tree that fell into the river, and the bigger regional council tried to dig it out, but then they didn't want to dig it out because it upset the roots of the invertebrate in the river. But it wasn't a native tree, it was a willow tree. That's what it was. And the fact is that there's a lot of invertebrate in the rivers that are still there after all these times, but you don't see them. There's a freshwater mussel and all these sort of things. But the younger people don't understand these sort of things. And a lot of the people sitting in the offices down in Wellington don't understand that either. And to actually map this, the SNAs here, now just another thing. I'm sorry about this, but I actually had the flu for a couple of weeks, so I'm not very happy. But in the Ōmāpere Manapā Valley, that has a big Maori population. Around the 70s, 80s, there used to be the odd pigeon flying around. But it was a part of life that, and we've got this block of land that I was talking about up at Manapā there. My parents happened to be churchgoers, so every weekend I used to have to go up there pig hunting, but it was also to stop the pigeon shooting and that sort of thing. Pig hunting, shooting pigeons, that was all part of life. That was, we knew that. But people were inclined to think that the locals were protective of the environment and that sort of thing, and the species and everything. Well, in actual life, it wasn't quite as simple as that. So I had to go up there because one thing is that we were surrounded with these Ōmāpere forests and the Puketi forest and what's become the Ramsey forest, state forest. Whenever there was a pig hunt, I'd have to go up there to make sure there are no dogs left up there or dogs on the actual sheep. This was not the dog. I'm the one that actually looked after that area, particular area, to stop the pig hunters leaving their dogs there. And of course, what happens with pig dogs is they don't chase just pigs. They also, the kiwi, they eat the cowrie snail and those sort of things. And so the Crown land, people think that, you know, someone was actually looking after that Crown land, but in a lot of areas they weren't. There's only lot, I mean, they couldn't. They had a heck of a lot of trouble on the east side of the water with pigeon and that sort of thing. And so having people on the actual land that are actually farming it and trying to make a living, you actually can't to do that. You have to be a carer of the land and all the indigenous things. What I'm basically saying is that and the change with the marriage situation, that, and as we know, that the previous government was pushing for all the top land to go back to the Maori and that sort of thing. But the perception of that someone's got to look after it. And that's what people forget. You put regulations on things, but in our particular case, if we aren't able to farm it, we can't pay the rates. There's no one paying the rates.
So, Mr. Hayes, well, thank you for your comments thus far. I'm just wondering whether you could indicate to us what specific relief you're wanting us, or what particular changes you're wanting us to make to the plan.
I think the crux is that the RMA require that the areas of SNAs to be defined, to be shown, and put. That's basically my biggest, because I was involved, as I say, I was involved with the first plan. That was a big hitch with the first plan, and why the council was chucked out was over the SNAs and the mapping.
So you want the council to commit to mapping the SNAs?
No.
You don't want the council to?
It is actually a waste of time.
And so you've got...
This is in the final district. I'm not saying about other councils and other regions and that sort of thing.
So you support council's current position to not map SNAs?
Exactly.
Okay. You've got some plans there. Were you intending to show us the photos?
Yeah, if you can, if you want to, I can.
Could you just explain what they are?
Did you need some help? Sorry. Wow.
Now this is, upside down. This is, I mean, it costs money to do this sort of thing. But this is the block up at Ōmāpere that we've got about 400 hectares of native bush. Okay, now we've also got down one of the boundaries here. We've also got that has just been sold to carbon credits. Now, we had a situation when we were doing the first plan. We had a situation where it was roller crushing there. Roller crushing, everywhere was being done with roller crushing, and the native bush is a bush at White Cliffs, and they were roller crushing it and destroying it and putting, that was, I mean, we were totally opposed to that sort of thing. But that went, you see. But they see now they don't roller crush, they buy fresh, yeah, now you can see that. Now that is set up so that we can actually add up, well, we have got the figures, for the areas that are in bush, in pine trees, and then when we can claim our carbon credits, which we can't, yet our neighbour there, the carbon credit people, can claim for the blooming carbon. We can't. We've got 400 hectares next door. We can't.
So what you're saying is you've already done your own mapping for the properties that you're in?
Yeah, we needed this sort of mapping for what we're doing.
Yeah. Okay. Are you happy to take some questions from us regarding the submission?
Yeah. No, this is just another map. This shows...
Oh, I'll get another map. Okay.
that shows the extent of the actual vegetation in the area. This is around the top end of the Wongo Harbour. Now, a lot of, if you look at the district council maps that show outstanding landscapes and all these sort of things, you're looking at it, you wouldn't think there's anything else. But there's massive areas. This is a map, sort of map that the district council should actually have as their records. Because this was back in 1977. This, looking at it, you can see that a lot of that land has already gone into pine trees and all these sort of things, and so it's only by having this sort of record that you can say, think, is it necessary for SNAs? Because there's so much of it already.
I've just got a question about what you said about the carbon credits next door. Do you mean that the trees on your land is native bush, so you don't get carbon credits for that? And
No, we can't.
is that your point?
There's
That
a point that John Miller, New Zealand Carbon Farming, the biggest farmers in the North Island. They bought that block of land, it was all in pasture. And then they've had problems with other things, with roading and goodness knows what. But their latest thing is that to appease the greenies and that, they are actually planting native vegetation amongst the pine trees, so that in the time when the 20 years or whatever it is, that it'll eventually become native bush. And this is what they use to back what they're doing. But we've already had I've had a block of land, and we want to do the third rotation of pine trees. And pine trees is not good for the soil. It's not like a fruit tree that has a leaf litter and that sort of thing. A pine tree is not like that at all. And so this idea that, okay, we'll get carbon credits so that we can turn it into a native bush is just completely utter crap. Because the area up there, the Summit Forest up there, it's on to its second, plantation now. That first plantation, sure, it had a lot of native bush underneath, and especially the ferns and that sort of thing. But basically very single species. But what they, as I say, here, there's parts in here, how do you make it incentive that help the farmer actually encourage him to have native bush. This is one of the key ones that would make it, but we can't. It's ridiculous, and this is all coming up with the carbon credits and global warming and everything.
Well, thank you very much, Mr. Hayes. I think we've sort of run out of time. We've got other submitters that we need to hear before us. So I think we should bring your presentation to a close now. I think we've got the point though. I think you've made your point quite clear to us. And so thank you very much for your submission and bringing your plans along and presenting those to us. And clarifying that position over the carbon credits. Thank you very much.
Yeah. Thank you for what you're doing.
We'll give you a little bit of a hand here. Your plans back in their roles.
I think it's a relevant point that he's getting regulation on his land if he's staying in the neighborhood. And then he sort of like this studio of the money, so they can't be one group that has to be
Yes.
It's really relevant. Yeah.
Mr. Stelton, Ōmāpere?
Yes.
Okay. We'll just let Mr. Hayes pack up his gear. Thank you again, Mr. Hayes.
Thank you.
and Tiffany is online.
Okay, so, Tiffany Kapakingi is on, well, you just have a seat here, wait till our hearing administrator comes back. She'll admit him into the video conference room. Is a participant waiting?
And yes, presentation share.
Okay, so, we've got the other participant here.
Yes, Tiffany, can you hear us?
Kia ora, Tiffany?
Kia ora. Kia ora tātou. Yep, I can hear you. Can you hear me?
Yes, that's fine. You come through loud and clear.
Bye-bye.
Okay, Ms. Dalton, you're gonna lead the way?
I am.
Okay.
And sorry, it's just yeah, just right. And it's pointing at my computer. And that just. Thank you. Kia ora tātou ko Makarena Dalton tōku ingoa. I'm here presenting the planning evidence on behalf of Te Ōpāre Commercial Development Limited with Tiffany online to answer any questions as needed on behalf of Te Ōpāre. Okay, a little bit smaller than I thought, but hope everybody can okay. So the structure of my presentation today, it's a fairly discreet, fairly small presentation, so hopefully it doesn't take too long. So at the outset, I'll just set out the Te Ōpāre context within the context of hearing 4, and then just focus in on a couple of key issues that were part of my evidence in chief. At the first point I want to make actually is, that I thought Mr. Wyatt with the Section 42A report did a really good job and resolved a number of issues that were sort of raised as part of Te Ōpāre's submission. So I just want to acknowledge that right from the outset. So for Te Ōpāre's context, and I won't dwell on this, but I think it's really important in the context of my submission.
Oh, yeah, no, feel free. I mean, a number of us aren't residents of Northland, so please give us a spatial summary of where the property is and how it relates to other parts of the district.
Sure.
That would be quite helpful.
So you would have, you probably don't remember because you've heard it from so many people, but Mr. Kapakingi shared this image in his presentations in Hearing 1.
Yes, we remember Tiffany from Hearing 1.
Yes, and what it sort of summarises is the key treaty settlement lands that were returned to Te Ōpāre as part of their treaty settlement. And I just want to highlight, you can't really see on this at this distance, but there's 5 or 6 parcels that are the sort of green parcels. Those are the fee simple parcels that were vested back to Te Ōpāre as part of their treaty settlement. And I also want to highlight those 2 purple and pink parcels of land in the centre there, which are 2 farming stations. So they are the commercial redress that was part of the settlement and amount to about 4,000 hectares of land. And so I've just highlighted these in the context of the treaty settlement overlay. I've just circled them there, those commercial redress blocks. So that's Te Raiti Station and Pukekāro Station. The point I want to make here is sort of summarised on the left-hand side. These were 2 sort of statements from Mr. Kapakingi's presentation in Hearing 1. And basically what he's saying is the treaty settlement process in itself is a robust and critical process that reconciles the relationship of Te Ōpāre to their ancestral lands. Ensuring that the treaty settlement land and is ancestral land in the Far North District Plan is critical. The treaty settlement process has, by legislation, recognised Te Ōpāre's relationship to this land as set out in their deed of settlement. It's really important, I think, in this context, to understand where Te Ōpāre is coming from and within the planning context. So just zooming into those key issues, I'm just going to start with defined terms. So I know that this is being addressed in a later hearing, so I'm not going to dwell on it, but Papakainga is a definition of plan and specified roles that we're dealing with here. So it means an activity undertaken to support Māori cultural living for tangata whenua residing in the Far North District Plan, in the Far North District. On Māori land, treaty settlement land which is subject to proceedings before Māori Land Court, general land owned by Māori, where it can be demonstrated that there is an ancestral link. And it may include residential, social, cultural, economic, conservation, recreation activities and marae. And just highlighting here that the PDP has sort of defined or put marae in the glossary of terms rather than as a defined term. Here it says that the complex, a marae is a complex of buildings which provide for the focal point of social, cultural and economic activity for Māori and the wider community. Given that marae are specifically mentioned in a number of policies and rules throughout the plan, throughout the PDP, I consider this would be better placed in the definitions chapter because it gives meaning to the rules. Into the rules, so IBR1, as part of the recommendations from the 42A, minimum necessary was recommended to be included. As I said, evidence of achieved, I consider permitted rules must be written in a way that removes any judgment and must be clear and measurable, i.e. you comply or you don't comply. Any material nuance or eligibility criteria, clauses, to the rule should be specified in some sort of criteria or general performance standard. I consider that this has already been achieved in the sub-clauses 1 to 14 of that rule, and I don't think minimum necessary is required. In my opinion, it doesn't add anything to the reading of that rule, so recommend it should be deleted. IBR2, so this is about vegetation clearance rules as they relate to Papakainga and marae, and kind of why I introduced the definitions at the beginning. So there's a number of changes that have been, those two underlined changes, the changes from the Section 42A recommendations. I agree with the tiered approach of allowing for, in per 1, number 2, a tiered sort of system of allowing for the first residential unit at a threshold, a specific threshold, and then additional residential units at a smaller threshold. And I think that tiered approach is appropriate as it relates to Papakainga development. And then going back to the sort of meaning of the word marae, I've also recommended that this should be deleted because the definition or the glossary described word of the marae includes the word complex. So just for simplicity and readability, I recommend that this the word complex should be deleted from per 1. And then just on the final sort of clearance thresholds outlined in my evidence in chief. The Section 48(2)A recommends that reductions in the Indigenous vegetation clearance within per 1, 2, in the residential, in the rural production Māori purpose in the treaty settlement land overlay, given the absence of SNA mapping and, sorry, so this was about rule IBR3. I agree with the recommendations there to delay that in the absence of the mapping and, the inefficiencies around having to provide an expert ecological report to comply with the permitted standard. And then the second point there around IBR4, rule number 2. There's been a recommendation there to reduce the clearance for multi-purpose treaty settlement land and rural production zone land. So the notified provisions included a 5,000 square metre threshold. The revised or the recommended amendments bring that threshold back down to 500 square metres. And I absolutely acknowledge the the analysis that was undertaken as part of the 42A that picked out or identified a number of other planning plans around the country with similar thresholds for analysis. I think in the context of the far north, the 5,000 threshold, 5,000 square metre threshold that was notified is more appropriate. It reduces, it's a change from what the operative plan allows at 2 hectares of Indigenous vegetation clearance. And in the context of the multi-purpose zone, treaty settlement land overlay, in my opinion, it gives, it will better give effect to the directions of 3.18 of the NPSIB around specified Māori land. That's it. Take any questions?
Okay, thank you. So it seems to me that there are just some really minor disagreements, really, from what you put in your primary submission and how the 42A report has addressed it. I think you've clearly set those out, so thank you very much. I'll see if the other panel members have any questions.
No, I think that's pretty clearly set out. It's helpful the way you've set it out, so thanks.
Yeah, very clear, thank you. No questions from me.
So the 5,000 square metres you support is notified, where it's been amended through the council office's 42A report. Just be mindful of, excuse me, Te Ōpōri's land holdings. And I think in the multi-purpose zone it said something like 10 units per site or something per 4,000 hectares or something, 40 hectares. So I got the sense that that made sense when you suggested that Te Ōpōri had supported it. Because that's pretty much the outstanding matter that hasn't been addressed. Well, it has been addressed, but not in response to Te Ōpōri's so I suppose I've got that, so thank you for presenting. Sorry.
Yeah, I think that was the main point, I guess, like, yes, there are specific provisions around Papakainga development and Midday, and then in the Rule R1, there are provisions for Ōmāpere gathering, doing clearance for cultural purposes, but, with whether it's Te Ōpōri or other Māori landowners, there's a range of uses that they need that land for with the limited, availability. They are restricted to that land. The 500 square metre threshold just doesn't align with, in my opinion, doesn't align with the directions of, the higher order statutory directions of the law. And in my opinion, the 5,000 square metres is more appropriate in that context.
And so, in the context of treaty settlement lands as well, in particular, because that has been through, as you indicated, a robust process, negotiations, etc., for iwi or hapu to do their own development for their social and economic well-being and just the land that they have, as you've indicated, because what they have is their own development or aspirations and outcomes that they want to achieve. So.
I just had a supplementary question to that with timing. In Muri Whenua, there are by iwi. What was the date that settlement happened for Te Ōpāre? Because one of the matters brought up is the timing of that. For example, Ngāti Kahu haven't had settlement yet, and these rules coming in now, and as you pointed out, 5,000 square metres, you're asking for that to be applied to give opportunities to utilise their whenua. So what is the time frame you're talking about between settlement and, you know, where we're at now in terms of this proposed plan in 2024?
Yeah, and I can definitely answer the question around the legislation. So the Te Ōpāre's Treaty Settlement Claim Act, it's 2015, the deed of settlement was signed in 2012. But, you know, the 2012 process is the end of years and years of negotiation with the Crown and research that goes into that process. So 2015 is the date of the treaty settlement legislation for Te Ōpāre.
Yeah, I just wanted to really ask that to give context to the panel based on, you know, what I see in the north, and there's only been a short time between finally having, you know, additional resources to actually utilise your whenua, and then our rules propose that are going to get more restrictions. So you're just saying that I understand the 5,000 square metre increase in that contract.
Okay, well, thank you. Mr. Kapakini, do you have any comments to make before we round out this presentation?
Yeah, just a couple, tuatahi tēnā koutou, ale taringa mai ana ki Wāmāwa kaupapa. Yeah, so 2012 was when we ratified our deed of settlement, and then there was a bit of back and forth between 2012 and 2015 to the finalisation of our treaty settlement legislation. But whether you count it from 2012 or 2015, yeah, we're roughly 10 years past settlement. But if you go back to when we originally lost our lands, we're about 165 years from that date. So yeah, that's the timeline that we're working with, and when we did receive our whenua, particularly our farming stations, Cape View and Te Laite, they were in pretty dire states. Although they were being worked by Landcorp, once the staff on those farms got word that Te Ōpāre was going to receive those stations as a part of their settlement package, they basically drove those farms into the ground. So we've had to do a lot of rework since receiving our whenua back, particularly our commercial redress. So yeah, those are just some points I want to share. And then secondly, I just want to reiterate Makarena's point that, and this is the case for all of our post-settlement governance iwi entities, is that we have commercial, social, economic and environmental priorities and objectives that we're all trying to balance and deliver simultaneously. So when it comes to considering a conducive treaty settlement overlay, all of those aspects need to be considered, and optionality is key for us as an iwi entity, as a post-settlement governance entity, and I'm sure others will agree. Those are the only points I'd like to add.
Okay, no, thank you. That gives us some helpful context in terms of the relief you sought. We wish you well as you develop your whenua and your land over the next coming years. So thank you very much.
Hold on.
And for this presentation also. Now that's the last party before this.
Yeah, unfortunately,
We're missing something, aren't we?
Bayswater and didn't know they were presenting today, so they're going to come
tomorrow.
I will scroll up and find the notes on that.
Yeah.
Okay, do we then proceed to the, should we not?
Yes.
Well, okay, well, we're in the end,
Kia ora.
we're in the position of being ahead of the game. So I think, well, but we have someone due to start at 2 p.m, so we'll adjourn to 2 p.m.
Okay,
And I think we can just use that extra time to catch up on other things.
right, I'll stop recording.